All right, so as I was saying, we're digging into the money book, getting deep into the U.C.C, Uniform Commercial Code, discovering how each one of us can become a private banker and do banking without any special requirements or licenses. Again, it's all in the private. And you should know by now that you can virtually do anything so long as it's not infringing upon anyone's rights or property in the private. All the regulations apply to the public. And so that's two different worlds altogether. All right. So tonight, I wanted to take some time and go over the offer of performance, conditional offer, which is one very special part of the U.C.C. And I want to get this on record, on video, for those that are not able to make it tonight, because I know specifically two people that need this and need to use it, and there's probably a lot more. People get demand letters, pay up or else. All right, and it puts you in a defensive mode, kind of puts you in a panic mode. It's like, well, what do? I can't pay. And then now you're looking at penalties. Some people are worried about going to jail if it's the IRS, and all kinds of, nightmares start creeping into our heads. But you don't have to feel that way at all, because what we're going to cover tonight is going to show you exactly how to deal with that. Now, a lot of people, for whatever reason, have kind of the knee-jerk reaction, as I do, kind of like to say, well, F off. I'm not dealing with you people. Well, as emotionally satisfying as that is, it's not the proper way to deal with it. It's always best to stay in honor of the process. Recognize they have a job to do. They're trying to do their job the best way they know how, according to the rules they understand, which is only about half of it. All right, so you're going to educate them on the other half. And stay in honor, allow them to do their job, explain the law, explain your position. And the offer of performance, it's real simple. It's a conditional offer. You're not telling them to F off. You're telling them, hey, I'd be happy to pay this, and I'd be most obliged, provided you could verify the validity of this request. And you have your list of points, maybe half a dozen points or whatever the number is. It might only be 1 point. Show me that you're the holder in due course on this mortgage and that you have the original note. And I want to see the front and back with the endorsement on it. Can you do that for me? If not, they're not the holder in due course. They don't have legal standing to make any demands, and they need to go away. It's that simple. Okay. So let's just jump right into it. I've got two versions if we have time to get through them tonight, and I'd like to just read through them line by line. And I'd love to invite your comments, certainly questions along the way. I'm no expert. I'm like anybody else who is just reading and learning and doing the best we can with what's written in black and white. All right. So please don't put me up on a pedestal. I just came across this stuff years ago and have been playing with it for perhaps a little bit longer than most of you. Okay, so let me pull those up. All right, so some people may do it different, but I always use certified mail, not registered. Registered is fairly cumbersome. But certified mail, return receipt requested, that's the RRR number. That's what the number on the little receipt slips that you get at the post office, or I should say the U.S. Postal Service, which is different from the post office, believe it or not. So you're sending this to the CEO or president of the company, in addition to perhaps other interested parties, someone that's in collections, someone that's in account receivables, or whoever has a job perhaps one that's written you a letter. You, of course, need to respond to that person who wrote you a letter, but it needs also to go to the company president or CEO because it includes liabilities to his company that he needs to know about. Okay. And so let's just get into it. And you guys might have suggestions as to how we might be able to do things differently or better in here, and those are welcome. So this is just kind of a work session. All right.
Mark, is this document something you're allowed to share with the members?
Yeah, I haven't figured out just how I'm going to do that yet.
That's fine. I'm just in the context of you exchanging some ideas and editing for a particular circumstance, because obviously this is not going to apply to everything, but in general the commentary looks really good, and I'm going to ask for on behalf of the group here.
Yeah. I mean, there's always room for improvement. I'm improving my own documents all the time. It's like, why didn't I see that? Boy, I could have done this way. So that's it's kind of like a work of art. You're really never happy with it.
Well, no, it's absolutely true. The just to clarify, it's not a matter of there's nothing wrong with it. It needs to be adjusted for a particular circumstance that we can't copy and paste this kind of a document. That's been the downfall for most of the quote commerce people that have been operating for the last 30 or 40 years, is that they think a piece of paper has value in terms of solving a problem, not the individual that's operating the entity that's been called out on some sort of an appearance of a public side liability. That's where I'm coming from.
Yeah, exactly. For example, I've got a debt elimination client who didn't follow instructions, didn't get the coaching he needed, and he sent the credit card dispute letter to a trucking company that gave him a loan.
Missed it by that much.
Oh my goodness. So anyway, I came back to him just an hour ago. I says, hey, you're not following instructions. You're wasting my time. If you want me to fix this, you got to pay more. That's all there is to it for my time.
Yeah.
So anyway, all right. So yeah, every circumstance is different. Every document needs to be made your own. You need to live and breathe the document, know it inside and out, and go over every jot and tittle, make sure that it applies to you and your situation. So, having said that, all right, paragraph 1, this is an offer of performance of necessity to extinguish the alleged debt liability, and you may either accept this offer, reject the offer, or object to the mode of this offer. If you find it objectionable that I use the statutes of this state civil code as an aid to understanding the nature and meaning of this offer, you should lodge that objection immediately, and I will resubmit the offer without any reference to the statutes of the state civil code or code of civil procedures. I'm not really sure why that's in there. I don't know that it needs to be. I mean, it's kind of silly. We're going to refer to the law, and that's what they operate by, and that's what we need to go by. But that's there. All right, paragraph 2. I wish to settle this alleged obligation in full. All right, that's important. Provided that you can verify and authenticate the validity of this alleged obligation and provide me the legal basis for which it exists, to which I am entitled by law as per my reasonable requests outlined below. Now think about it. Who can collect a debt when they can't even prove that they're the legitimate owners of the debt? All right, so that's just fundamental right there. Therefore, this is a written request for validation of the debt referred to in your recent statement or letter. The Federal Trade Commission in the U.S. Code requires that debt collectors cease collection of a debt until verification of that debt is mailed to consumers. Okay, therefore, by law, you should cease collection efforts on this alleged obligation until this matter is resolved. So that's number one. Number two in this particular letter, but they need to prove who they are and what their legal standing is. Okay, that's obvious. So, paragraph 3, I've just discovered that there may be fraud or accounting irregularities, wink, wink, involved in this alleged debt as it relates to the Truth in Lending Act, per 15 U.C., section such and such. Now, maybe someone can correct me. I've looked at the Truth in Lending Act, and all I can find is that they need to disclose the costs, the interest, the fees, that kind of thing. I was looking for something more deep in there, but if anybody has any information on that, I would like to see it. But it's certainly a good general reference to make. Truth in lending. In other words, you need to tell me the truth. And when banks and credit card companies, mortgage companies do their so-called loans, there is so much that they're not telling you that is the truth. All right. They're withholding so much information. We've covered that before. I'm sure we'll cover it again, but not now. So that's one, the Truth in Lending Act. This notice is timely as per the delayed discovery rule, even though this might be a debt of, a year and a half ago. Okay, the delayed discovery rule, you can look that up, as I have just discovered the potential irregularities with this matter. If this is in fact a bona fide, legally correct debt obligation, it's my full intent and purpose to pay it in full, in money of account of the United States, upon presentation of valid documentary evidence which would support the claim of debt. Now, this is kind of a tricky little thing we're doing here, mentioning money of account of the United States. This is a term that was used in the Coinage Act of 1790. What was it? 1 or 2? We talked about this last week. The fact is, money of account of the United States has never been defined. Okay? So if they accept those terms to be paid in money of account of the United States, well, you're happy to pay them as soon as Congress can actually define what that is. Money of account of the United States is not defined as money. It's not defined as currency. It's not defined as negotiable instruments. It's not designed as Federal Reserve notes. It's not in any of the money definitions. This is a definition unto its own. Okay. So one, if they didn't want to play with that as such, you could remove that. Just pay it in full. All right. In currency. Understand what the definitions are of currency or just or money. And
so Mark, this is really important what you're touching on right now, and because this may have a particular applicability to a mortgage note, as an example. If anyone has had the opportunity to look at their actual mortgage note, even after the fact, and its associated deed of trust, there are 2 call-out paragraphs in each of those instruments that define the species of currency that they want payback. Now, that is not legal for them to stipulate the type of currency, because if a type of currency is presented as payment, they accept it, and I'm talking about specifically the note itself, and they demand a different species in currency, there is no legal ability for anybody to do that. So by default, the stipulations on the note instrument itself and the deed of trust are defective because they're calling out a specific species or species of currency, interestingly enough. And it's a mixture of debt instruments and potentially, if we consider private instruments like a note security, which is actual currency, asset currency, it's mixed up. So I want to share that with you. So because you've made all this effort to put this on the recording, this is a huge point. If you have one type of currency that's used in the initial transaction, it cannot be called out to be paid back in another species of currency. It can only be called out in legal currency. That's how you pay a debt. Legal currency is defined in 18 U.S.C. 8, as you just hinted at a moment ago.
Okay. So what you're saying is that you're paying it first by virtue of presenting them with the mortgage note, which is one species of money. Note is a negotiable instrument.
Correct.
Could be looked at as a security. And then they're asking for a different species of money to be paid back. So that's the mixing. They're taking one thing but requiring another.
Yeah. And it's a defective qualification with on the face of the instrument. And what makes it especially defective is that once the note has been accepted after the 72-hour, 3 days rescission by the quote mortgage lender, they deposit it. And if you have a copy, a certified copy of the note front and back, you will see pay to the order of. So when you see an endorsement that says pay to the order of, that means it's cash equivalent.
Mm-hmm.
That means that the purchase that you just made was literally paid for.
Yeah. Yeah, absolutely. And that's why when you're sending a dispute letter to the validity of a mortgage and they can't or won't, they don't want anybody to know that or see that. Let's just say they either can't or won't present you with certified front and back copy of the note, then they have no legal standing to make any demands of any kind. So they're damned if they do and damned if they don't. If they do present that to you, you can make the argument that it's already been paid for and further payments are unnecessary.
It's not an argument. I need to underscore that. It's not an argument. It's a fact.
Yeah. All right.
An absolute fact.
Good point. Yeah, this is amazing once you get into it. So some people who are not used to getting into some of this legal stuff, I know their eyes can maybe start to gloss over. But once
that's okay. Let them. They just watch the session over and over again, and the blurry eyes go away.
I want to say that once you start understanding the impact of what we're talking about, a whole new world opens up for you.
God, true statement.
I mean, my goodness gracious. So let's move on. Good. Thanks, Jerry. Number 4, if or when validated in accordance with the law, key point, okay, this then constitutes my good faith offer. And this is what we're doing. We're acting in good faith. We're not saying F you, all right? Good faith offer to pay the alleged obligation in full or in agreed installments when you can show me the reasonable and lawful basis for your claim. And nothing unreasonable about that. You have a claim? Okay. Show me the basis for that. Although reference is made herein to state statutory language, I certainly do not rely upon any statute, state or federal, for the legal significance of this offer. The statutes of the state civil code, for example, are quoted herewith merely as an aid to understanding the nature and meaning of an offer of performance. Okay, that's a key term you'll find in the U.C.C. The existence of these statutes is clear evidence that a tender of this type has been used effectively and extensively for commercial and business purposes throughout the history of America. The legislature in this state is merely codified the known common law significance of an offer of this type. The legislatures in other states have done the same thing, and numerous state courts have created a well-established stare decisis body of law with regard to an offer of this type. Okay, so this is very well established in law. We didn't just, whip it up after a couple of drinks at the bar, right? So, offer to extinguish the alleged debt liability. So here's the offer. This is an offer of performance with intent to extinguish the alleged debt liability. Alleged debt liability. As noted above, as an aid to understanding the nature and meaning of this offer, please note the following language. From the statutes enacted in virtually every state legislature, setting forth the commonly understood meaning of such an offer, the state civil codes, which are generally entitled Extinguishment of Obligation, which you can search for, or similar wording, an obligation is extinguished by an offer of performance made in conformity to the rules herein provided and with intent to extinguish the obligation. Okay, so what they're saying is this offer is made in conformity to the rules and with the intent. Okay, so we're very clear on that. We're establishing the intent here, and we're going to look into the rules here as we go along. So, and state civil procedures entitled Rejected Offer as equivalent to production and tender of money, instrument, or property, an offer equivalent to payment. All right, now this is starting to get interesting. Let me read that again. Rejected offer as equivalent to production and tender of money, instrument, or property. An offer is equivalent to payment. Okay, now if you were with us or reviewed our conversation last week, in the money book, I've got a paragraph talking about how Alice in Wonderland was raising rabbits and tomatoes on her back porch, and the city came along and gave her a big fine for being outside of zoning regulations. Okay, and she sent a negotiable instrument on the back of a napkin, which they refused, and she thanked them very much for being so friendly, exactly because of this concept. All right, so I hope you're tracking with me here. So in the civil code, stating an offer dependent upon performance of conditions, performance of condition precedent, or similar wording, okay? And I would add here, performance of a condition precedent to establishing the lawful basis for the debt, okay? When a debtor is entitled to the performance of a condition precedent to or concurrent with performance on his part, all right, that debtor would be you, the person they're asking to pay. When you're entitled to the performance of a condition precedent, we're asking them to validate the debt, right? That's the condition precedent. It's like, hey, I have your bill. Yeah, okay. Show me the underlying basis for this. And that's a condition precedent to your compliance with their request. Okay? So he or you may take your offer to depend upon the performance of such a condition. Okay? So in other words, you agree to pay based on the conditions that you set. That's why we call it a conditional offer. We offer to pay conditional upon you presenting the facts and the law to establish your right to ask me for money. Okay? So this offer is to pay the entire balance due as a debt liability, either in full or in agreed upon installments, including interest and penalties, and is made conditional upon performance of conditions precedent to which I am entitled by the fundamental principles of American jurisprudence in law, including, among others, the Fair Debt Collections Practices Act, Truth in Lending Act, the Uniform Commercial Code, such conditions being namely presentation of documentary evidence showing the factual grounds of the alleged liability, to wit. And so here they are. Okay, this is what I'm asking for as conditions precedent to this offer. All right. Show me these things and I'll make the offer good. And the beautiful thing is, you ask, well, what if they did present what we're asking for here? Well, first of all, we know in advance they can't because we know the game. But let's just say they did. Okay, so they provided everything you asked for and they have a legitimate claim. That leads us to what we're going to talk about next week is, okay, you're obligated to pay. And this goes back to Jerry's previous comment, pay in what specie of money? How about a negotiable instrument? So we'll get into that next week. So the first condition, A, show me the original or certified and notarized copy of the original contract, and we should put on there front and back, which alleges, I'm going to do that right now. Front and remember, I'm typing with basically one hand. Okay, which alleges to have created the debt obligation in the first place, which establishes you as the holder in due course. Okay, if you're not familiar with that term, look it up in Black's Law Dictionary. You as the holder in due course of the original instrument. I'll tell you on these mortgages get passed around from one trust, they get sold and resold. There have been people that the trust has told them, well, we can't find the original note, but we have it, but we just can't find it. Well, that's when you say goodbye. Okay, that's pretty simple. And the way they've messed things up with the securitization, putting all these mortgages into a trust and then securitizing the trust and selling the trust as a security, they get themselves all balled up. But that's another topic. So B, if you are not the original creditor in the primary contract, which is often the case, okay, don't be surprised, documents or documentary evidence showing the legal transfer or assignment of beneficial interest in the contract and in conjunction with evidence of the lawful consideration that you paid to support the lawful transfer of beneficial interest of the alleged contract note to you. Okay, so in other words, if you're not the original creditor, which is not at all uncommon, you can expect that in most cases, all right, show me the assignment of beneficial interest and the transaction, the lawful transfer of money and beneficial interest of that contract to you. Okay, show me the financials of the transaction and the documentary evidence that that transaction actually took place. Well, we're just a debt collector, a bill collector. You know, this other bank has the debt. Well, if you don't have that, then, you know, I can't talk to you. All right, and there's other ways to handle bill collectors, debt collectors. We have a whole book on that in our NATF debt elimination package. That's a whole nother study. So then we go to C, documents or documentary evidence showing facts necessary to establish that a loan or credit was actually made to me from your proprietary holdings. In other words, your own money, whereby you or the original alleged creditor, if you're a collector, actually transferred your money, assets, credit, or other property from proprietary accounts to me. In other words, show me the accounting forensics, show me the transactional debits and credits. All right, well, this came from your account to me or my accounts, whereby this transaction would be wholly different and apart from the explanation by the Federal Reserve Bank of Chicago in their publication, Modern Money Mechanics, under section bank deposits, how the money expansion works, illustration number 2, as to how the banking business operates, to wit. Now we have that publication again in the NATF debt elimination resource.
Mark, on this paragraph here, when you said actually transferred proprietary holdings, I'm going to ask you to consider using the word pre-existing to the transaction. Because what they do in terms of what you're just describing here in modern money mechanics is that they will literally take that note security that we've signed and deposit it as cash. And that literally creates an increase in their liabilities, meaning that they owe you money. And they also then increase their assets, to which they then profess to have created a loan for you. So the word pre-existing is really important from a timing perspective, because it's possible if you have just a general accountant come in and say, okay, here's the transaction. Yes, we deposited this, we increased the liabilities, and we sent you a check, or we distributed the depository credits to such and such, to the seller.
Yeah.
You're sunk. But the key is pre-existing, before you deposited my cash payment. Show me that you had a loan with your pre-existing funds before you accepted my note security. And it cannot. As we talked about last week, they're literally prevented under 12 U.S.C. 83 from lending their own deposits, assets, and securities. So again, this long story short, pre-existing is key.
Yeah, that is key, because after they deposit your note, then their assets go up, and then they do have the checkbook money to write you a check.
Yep.
But that deposit came from you.
Yes.
Which they.
But that's not a loan. That's an exchange. That's an exchange of currency. That's literally no different than you and I walking into a bank with a check draft, and we're cashing it. And by cashing it, that means we're exchanging it for a different species of currency, typically Federal Reserve notes, or maybe 300 stacks of quarters. But it's a currency exchange. It's not a loan.
Yeah, exchanging one species for another. Okay, good point. All right. So we do have. You can find that online too. You can find modern money mechanics. It's fascinating to read. So anyway, to wit, of course, they do not really pay out loans from the money they receive as deposits. This is the Federal Reserve talking, okay? What they do when they make loans is to accept promissory notes in exchange for credits to the borrower's transaction accounts. Okay? That's just what Jerry explained just now, okay? And that's the Federal Reserve telling us this in a publication that's available. It's not being published or distributed anymore, but it is available on the internet, and we have a copy. Okay, this confession by the Federal Reserve Bank of Chicago would indicate that nothing of value is being loaned, but rather the promissory notes are accepted as the asset on deposit from the borrower. It is then illegally converted from a bank liability. Now understand that when a bank takes a deposit, it owes that deposit to the depositor, which means that's a liability. They have to pay that, all right? They change it from a liability to a bank asset and given back to the borrower via demand deposit account, which is checkbook money. And the bank has never put one dime at risk and has loaned nothing. Therefore, no loan actually ever took place or now exists. Okay? There's no such thing as a loan. They call it a loan. That's misrepresentation and false advertising, which last I checked, those are crimes. All right, paragraph D, documentation of facts necessary to establish that the bookkeeping entries of the alleged loan reflect that upon making such a transfer of credit or check or demand deposit account money in the alleged loan or lending of credit, that the net asset position of the bank was depleted by the same amount, thus showing that you have been deprived of the use of these proprietary assets which were advertised as a loan, and thus you would be entitled to relief and restoration. So again, this is one item that we're asking for them to justify their position that they made a loan of their money to you and you owe payments back. All right, they can't provide it, right? So we're asking for things we know they can't provide. So we go to E, all right, as if it isn't enough already. We continue. Documentation or documentary evidence that my promissory note or contract or agreement was not the asset credited to the books. Show me that, which in turn loaned back to me, which would in fact then indicate that you loaned me something of value or loaned me nothing of value. That there was any loan as falsely advertised, and you have nothing at risk in this arrangement, which would thereby put you in a position of illegally extorting me of the fees, oops, getting on the thin ice here, usury, and the good faith and credit of my name and reputation in commerce as my family's financial future using fraud and deception with your bait and switch illegal lending practices. But apart from that, I love you guys.
Perfect. Perfect. Always end with a smile.
Yeah. So show me that if you would, please. All right. That's all I'm asking for. Nothing much. F, documentation of facts necessary to show that your corporate entity, in whatever form, is currently in good standing with the Registrar Secretary of State in its state of domicile. I was working with a foreign banker and just started doing some research on it, and they were not keeping up with their corporate filing requirements, and the company was stricken from the company registry of the country. So these things happen, all right? So show me that you're registered and that you have proper authorization and licensing to be operating in accordance with all the laws in this state as they relate to banking, finance, lending, and collections. Okay, so show me that your company is in good standing. Typically, a corporation can go to the Secretary of State and they can request a certificate of good standing. It means they've been paying their annual registration fees, whatever taxes are involved, maintaining their filing requirements, change of directors notices, whatever the corporate requirements are. And so the Secretary of State can issue a certificate of good standing for any company. All right, so just be aware of that. I've had to get one several times. G, representative samples of all public advertising being circulated at the time that the alleged contract was initiated, which reflect the type of services you are offering to me in the public at the time. Low-cost loans, get your mortgage, low points, housing loans, all right? That's what you're asking for, which will just prove your point, and they won't provide it because they know it will. Please take note that if these 6 elements cannot be met, then there is no liability for me to pay, which I believe to be the case. If in fact the liability alleged by you is a liability for which I am made liable for law, liable for by law, then I am certainly entitled to a presentation of evidence sufficient to demonstrate the factual validity of these claims as per the above. So in other words, I have every right to ask for these things. So please do. So 21, the law presumes that men act fairly and honestly, that their dealings are in good faith without intention to cheat, hinder, delay, or defraud another. And if any transaction is called into question, it is equally capable of 2 constructions. One that is fair and honest, the other is unfair and dishonest. Then, in that case, the law presumes the transaction to be fair and honest. Therefore, I'm not going to jump into the conclusion that you are manifestly attempting to put one over on me by asserting a debt liability where none exists, in attempting to collect a debt which I do not owe by fraudulent or deceitful means. Therefore, I make this good faith offer of performance with intent to extinguish the alleged debt obligation. Okay, so I'm acting in good faith, and I expect you guys to act in good faith because I know you're really good guys, and you wouldn't do anything like that to me. So just show me, and we'll be good. All right. Objections must be immediately stated. Although the principle is well established that if you have any objection to my offer, its terms or its mode of delivery, you have the duty and the good faith obligation to express such objection to me immediately and not harbor said objections, and then to surprise me at some later date. I state the following for its explanatory value in this regard, and that I do not rely upon it as the legal basis for this requirement. State civil codes adopted by virtually all states, adopted under the Uniform Commercial Code, worded in similar terms in all states, to wit, and I'll add here that the Uniform Commercial Code in all states except Louisiana have been adopted verbatim in one title of the state statutes. So you'll find the exact same U.C.C. codification in each state, albeit it'll probably be in a different title. In Colorado, it's Title 4. In Oregon, they have a different numbering system. Okay, but the U.C.C. is the U.C.C. is what we're saying here. Okay, so time for objection to mode of offer. Objections to mode of offer. All objections to the mode of offer of performance, which the creditor has an opportunity to state at the time to the person making the offer, which could then be obviated by him, are waived by the creditor if not then stated. Okay, so they either need to speak now or forever hold their peace. Okay, and state codes of civil procedures, objections to tender, time, specification, objections to tender must be specified. Now, we saw earlier that an offer to pay in full is the equivalent to a tender of payment, right? So we're dealing with the tender. So the person to whom a tender is made must at the time specify any objection he may have to the money, instrument, or property, or he must be deemed to have waived it. And if the objection be to the amount of money, the terms of the instrument, or the amount or kind of property, he must specify the amount, terms, or kind which he requires, or be precluded from objecting afterwards. So you see, when they present you with a bill or a demand for payment, that's an offer. It's a presentment. And it's up to you to accept that presentment or make them a counteroffer with additional terms that are your terms. All right. And that's what the conditional offer really is. It's a counteroffer. You're saying, hey, I'll accept your offer to pay, provided we add these additional terms and you show me these things. Okay. So look at it that way. All right, so 23, therefore, if you have any objections to this offer of performance, you have the opportunity to state said objection immediately in writing, and also the obligation imposed by the principle of good faith to do so. If no objection is made, you waive your right to any objection at a later date. So again, speak now or forever hold your peace. Okay. Attempt to extinguish the obligation. I'm making this offer with the intent to extinguish the obligation, and is well established in law that the obligation is extinguished by a bona fide offer of performance to pay in full, which is refused. Okay, that's in the U.C.C. as well. We'll get to that at some point I think we already have a little bit last week. An offer to pay in full, a tender of payment which is refused is a debt paid at law. Okay, that's verbatim paraphrased direct from the U.C.C. There's a section of the U.C.C. that states that, and we'll probably get to that. So the offer stops the running of interest. So until you come up with these things, stop charging me interest. All right, the effect of an offer on interest and incidence of obligation, an offer of payment or offer of performance duly made. So the title of the thing offered to the creditor stops the running of interest on the obligation and has the same effect. Well, it's kind of a moot point because they're not going to be able to come up with the conditions that you've required. And so the entire debt's going to be extinguished anyway. So that's kind of superfluous, but hey, why not throw it in there? It should be possible for you to immediately produce, for my consideration, the grounds upon which you assert your claims, if such grounds exist. And those grounds must be substantive on a point-for-point basis on the issues raised above. In other words, you can't just say, oh yeah, well, we have this, next point. No, that doesn't fly. Show me the facts, show me the documentary evidence, show me the law which contravenes anything that I'm saying, and that would be a substantive point-for-point reply. But blanket terms, blanket rejections, ignoring the points, you're screwing yourself, all right? Anything less is deemed a non-response, which would then be deemed consent to my averments. Averments in law is a statement, my allegations. Your consent to my allegations by your silence. If I receive no response from you, such lack of response or rejection of this offer accords the only plausible explanation for such lack of response or rejection is that you have made an erroneous and invalid debt assessment for which there is no factual and reasonable basis, and by operation of law, the books will reflect a zero balance, and all collection efforts shall cease. Okay. Now we can take this one step further. All right. Getting the debt zeroed out is one thing. What about the damages they've caused by taking your payments under fraudulent pretenses and denying you the economic opportunity, the time value of money that you could have benefited from by having those funds in your own pocket at that time? All right, so that's
Mark, I got to tell you, bud, that is an incredible point. It needs to be in here in one of your bullet points. It literally needs to be in because you're not going to just ignore the fact that you've literally paid them thousands, perhaps maybe hundreds of thousands of dollars that they have collected under threat, duress, coercion, and false and fraudulent assertions. Those are serious crimes.
Yeah.
Serious crimes.
In our debt elimination program, we're demanding repayment of the payments made. Now, my thinking is to this is step one: zero out the balance, prove the fraud, goodbye. All right. Step two would be getting more aggressive and getting on the offensive on a whole different platform. That's my thinking, rather than incorporating it all into one, which kind of diffuses the issue a little bit. But we can talk about that. What do you think?
I'm totally with you on everything that you're stating here. And you're already alluding to the fact that there's a legitimate claim that an individual has on monies paid collected under surreptitious circumstances that were false and fraudulent. And I agree with you also that you don't need to put it in this particular letter, but part two is going to demand that after they zero out the account.
Yeah. I kind of look at it as a two-step process.
Absolutely. Yeah. You're totally cool. Thanks.
Yeah. Yeah. So, yeah. Yeah, good stuff, good stuff. And just think of all the people that could be well off if they executed this process properly. I mean, my only fear is that the banking system's going to collapse before we can get to them. So that's another thought for another day. But we'll see. We got to put the pressure on, and man, I would sure love to get some people going here.
Yeah.
And we've got a few test cases in the works right now. We've got an SBA loan, we've got a mortgage, we've got a few credit cards, stuff like that. But I'd love to get some more cases in the pipeline, because this is, I mean, this is irrefutable. They can't wiggle out of this. And the beautiful thing is, this is done without courts. This is all done in the private.
That's the best part.
Yeah. You don't need a corrupt judge to, try and.
No, the point of your letter is that you're totally acting in honor, and you're asking for equivalent.
Yeah. Yeah.
And that doesn't need a judge. That needs common sense. That needs honor in return, particularly for somebody that's in a position of trust and authority, running a multi-$100 million or maybe $1 billion corporation that's defrauding the public. And I really don't care whether it's because the Federal Reserve modern money mechanics says it's okay. It's not okay.
Yeah.
It's just people don't care enough to even read and learn about it.
Yeah, I'll give you my money. I'll give you.
Sure. Yeah, loan. Yeah, you bet. Okay, cool. Yeah. Okay. So
the banks are getting paid 4 or 5 times the value of your property.
I have to go back to comment, because it's not that the banking system is going to fold in on itself. It would be so easy if the mortgage company said, hey, look, we don't really do loans, but we do currency exchange. So if you'd like to exchange that note security for another species of currency, we charge $30,000. If you're good with that, then write your note security to us, and then we'll just deduct that out of the proceeds of the face amount of your note security. You good with that?
Yeah, and you wouldn't have any payments.
Wouldn't be a problem with that. And the seller of the property gets paid. The guys that constructed the property, that bought all the stuff at Lowe's and Home Depot, they get paid. Lowe's and Home Depot get paid. There's nothing to collapse, because it's all being run honorably.
Yeah.
Instead of under subterfuge.
Yeah, the banks make huge fees.
God, yeah.
Sure.
And that's why all the banks over the last 5 years, you're seeing this consolidation of banks, because they're trying their level best to get out of the paper business. Because if they don't have to show an actual blue wet ink signature, and there isn't any back or front to the DocuSign document, and you don't know any different, that's why all the pressure is on them to do that right now.
Yeah. It could have been so great, if they weren't so damn greedy.
Yeah, seriously.
It's not just about business sense either. It's as control. And look at all the properties they're sweeping up, in foreclosure right now.
Absolutely.
BlackRock.
Yeah.
They're just buying up entire neighborhoods.
Yeah.
So
it's interesting how they're doing that too. You think they're you think they're doing it with cash, or do you think maybe they're issuing maybe a negotiable instrument?
Yeah.
It's such a joke. I mean, once you see this, you can't unsee it.
Yep.
God.
So,
and they literally have no capacity to issue that document, because it can only be a debt instrument if it's coming from a dead thing. If it's coming from you and I, we are that living energy for asset currency. And that little comment that you read back last week about the Federal Reserve book saying that the Federal Reserve Bank can create currency and so can the public.
Yeah. Yeah.
Minor point in passing. Jeez.
And anyone can be a private banker. You don't need to be registered, certified, or licensed to be a bank. You can be a
You
bank.
know what? If you purchased a vehicle or a house, you are a private banker. Not can be, you are.
Yeah.
Because you issued the negotiable instrument and you signed it in wet blue ink and they stamped it, pay to the order of on the back of it when they cashed it.
Well, yep. So wake up, people, wake up. You are a private banker. You just need to learn how to operate as one. That's what we're trying to get to here. All right.
Yes.
You got the title. Let's just get the training done here. So here's some case law that tender is an offer with the intent to extinguish an obligation when properly made. It has the effect of putting the other party in default if he refuses to accept that. So if they refuse to accept your offer, your conditional offer, the conditions that you put on, which are the additional terms of the contract that you're imposing, taking control of the situation, then you say thank you. Thank you for refusing. By law, operation of law, this obligation is extinguished. All right, now let's talk about reparations. Wait for my next letter. All right.
Beautiful.
All right.
Seriously beautiful.
Yeah. So I don't need to read through all this case law, not too much, but there's some good ones here that you can refer to. A tender need not be kept good when it appears that it will not be accepted. Okay. And again, what if it is accepted? Well, you're a private banker, issue a negotiable instrument. There's so many ways. There's so many ways to do this. All right. Response to this offer must be within 10 banking days of receipt thereof. So I'll give you, basically 2 weeks to reply because obviously.
So let me ask you something. Does banking stop at 3 p.m. on Friday?
Well, some offices do, but banking.
No, I didn't say office. I didn't say offices. I said, does banking stop at 3 p.m. on Friday?
Of course not.
No, it doesn't. So what you just said is 10 calendar days because banking is 7/24.
Oh, I get your point. Yeah. Okay, well.
And they can't refute that, by the way, because I can guarantee that if they got a closing at 4 p.m. on Friday, they didn't wait till Monday morning to deposit your note security. It went in that day. No. And particularly private banking is expressly operating 7/24. So I'm highlighting that because you put it in red, but I don't want anybody that's reading this or listening to gloss over the fact that everybody thinks, oh no, it can only be 10 calendar days and I can't count the weekends and I can't count holidays. And that's freaking BS.
Yeah.
10 banking days is 10 banking days.
Yeah. Would you suggest we change this?
No, I absolutely love the fact that you said 10 banking days. So everybody that's on the call or listening to this should go literally look up banking days and see what they find out.
Good point. Good point. Okay. Yeah. All right. Let's do that. So there's your notice of offer of performance. Hey, man, I'd be happy to pay what you ask, but just need these terms. You need to kind of show me where you're coming from on a few of these things. And we go from there. I love it. I don't know about you.
Love it. Absolutely love it.
The law is just thrilling once you start to understand what we're really talking about here. So, all right. Well, then we got a similar one over here. How are we doing on time? We're getting kind of short. So I won't go through this point for point, but this is the same concept dealing with the IRS. And I know not very many people have IRS issues, but in case you do, you might want to know about this. Okay?
Yeah, love it. Love it.
Okay, so this incorporates a lot of 26 U.S. Code, Title 26, which is the Internal Revenue Code, IRC. And a lot of this talks about, well, you're requiring that I pay according to 26 U.S.C. such and such, but the Code of Federal Regulations for that are in Title 27 of the CFRs, Code of Federal Regulations. Title 27 only relates to alcohol, tobacco, and firearms. And I'm not involved in the ATF, so therefore, your stipulation threatening me with this code in Title 26 is pure bullshit. Which is basically what much of this says here. Okay, estimated tax penalties. And here, and we do this all the time. If I'm in error, I ask you, please provide the specifics in the statutes and the regulations. Okay, let's go with both of those. And the specific case law to rebut my assertions, point for point. Using the broad brush to say that this law is frivolous argument, which they will. Oh, thank you for your letter, but this is all frivolous, pay up. And I have a special letter for this frivolous argument bullcrap, and you would love that. Maybe we'll do that some other time. I think we did the other night, a couple of weeks ago. So anyway, I have no desire to argue about paying any tax, which I might owe, okay? So I've searched Title 26 of the U.S. Code, and then I've not found anything that requires me to file a return 1040. All right, so here's the law that I come up with. All right, here's what the Supreme Court says. I'm not involved in any trade or business within the United States by definition, and as such, my private activity is deemed to be a foreign estate or trust, which is not includable in Subtitle A income. All right, and we get to that point by analyzing some of the definitions stated up above. I haven't gone through it in detail, but that's the conclusion that we come to. And here's the definitions. Okay, and this is good. I'll go through this because this is important. Definitions, when used in this title, were not otherwise distinctly expressed or manifestly incompatible with the intent thereof. All right, so definition of the United States. Are you a U.S. citizen? A citizen of the United States? Well, the term United States, when used in a geographic sense, includes only the states and the District of Columbia. All right, so we know what the District of Columbia is, 10 square miles. What's the definition of states? We'll get to that. According to the, okay, so I've learned that this statement perhaps is no longer true, meaning that includes means at the exclusion of everything else. So I'm going to take that out. That's potentially incorrect. So when used in a geographic sense, includes only the states and District of Columbia. Okay, so what are the states? Well, definition 10, state. The term state shall be construed to include the District of Columbia. All right, well, what else? District of Columbia. What is a state is a District of Columbia. So if we go back to the definition of the United States, inserting the definition of state, we can read it as the term United States, when used in a geographic sense, includes only the District of Columbia and the District of Columbia. All right, okay. So that's pretty narrow. Are you involved in a trade or business in the United States? Okay. If so, you're going to be probably subject to Subtitle A income taxes. Okay, all right. Fair enough. Trade or a business. People would think, well, do you run a restaurant, a coffee shop, you know, a beauty salon, some kind of trade or business in the public? All right. Trade or business definition number 26 in Title 26 of which is the Internal Revenue Code, right here, Section 7701. The term trade or business includes the performance of the functions of a public office. All right. Well, what else doesn't it? Doesn't say. So if you're not in a public office in Washington, D.C., then you're not involved in a trade or a business among the states or the United States. All right. So
Do you know that the president of the United States has to renounce his U.S. citizenship when he takes office
no.
because he represents he's the head of state of the United States of America, and you can't have a dead entity that's created in the District of Columbia representing the United States of America, the nation on the land, or its people. Isn't that interesting?
Wow. So what's the process for that? I mean, what's the mechanism?
Oh, they have to do it in front of a justice. They have to swear that they're renouncing it, and they document the fact that they are renouncing their U.S. citizenship, not an American national, but their U.S. citizenship.
Yeah,
and that allows them to take on the duties as the head of state for the nation.
Wow, I never knew that.
Yeah, it's crazy.
Okay. So foreign estate or trust, any estate or trust, the income of which from sources without the United States. So if you're not in DC in public office, you're deemed to be engaged in commerce generating income for a foreign estate or trust when it's not effectively connected with the conduct of a trade or business, i.e. public office, within Washington, D.C., is not includable in gross income under subtitle A. Well, golly, and B.
That's great.
Boy.
That's great.
Okay, so the term taxpayer means any person subject to any internal revenue tax. And boy, they're playing with words here, lowercase internal revenue tax. You got upper capital I, capital R. That's a different thing. And they got so many ways of slicing this. But what's a person? All right. Most people are starting to learn that they're not engaged in a public office in Washington, D.C., so they're not basically a taxpayer by definition. So in this particular offer, until you can prove otherwise in facts and law, I'm not an individual taxpayer by definition who is required to file a tax return. So please confirm this legal position to me in a letter stating that I'm not liable for this return or related liabilities. Okay, until such a time as I hear from you or your office with the facts and law giving substance to any assertions of my error, I will take the position that I am no longer liable. So unless you tell me different, this is what I'm going with. Okay, that's what you're telling them. Failure to respond is acquiescence. Silence is acquiescence. I've given you guys plenty of time, several opportunities to correct me if I'm in error. Of course, they never respond because they can't. They won't put it in writing because that would expose the fraud. So it just goes off into never, never land. All right. So then
it also makes whoever signs directly liable for the fraud.
Oh yeah.
That's why those letters are never signed by an individual. They're always signed by. They're always titled from a department, which doesn't exist, obviously.
Yeah, that's a key point. An unsigned letter has no authority. There's a maxim in law that states without risk, there's no authority. If you don't put your name on a document, you're not attesting to its validity and taking the risk for any errors. All right. So no risk, no authority. No signature, no authority. All right. So, but here's where it gets more fun and games. So then we go to, all right, we've established our legal position up above. Tell me if I'm wrong. All right, now let's go to IRS Publication 1, the Taxpayer Bill of Rights. All right. Hey, guys in the IRS, you have an obligation to respect my rights according to your publication number 1. Okay. I have the right to be informed. All right. Tell me if I'm off point on any of these things, all right? If I'm in error, you need to tell me, inform me. I'm entitled to quality service. You need to respond to me in a reasonable period of time, okay? And answer my questions, all right? I have the right to pay no more than the correct amount of tax. Well, I've told you the amount of tax that I've determined is due according to the law, which is 0, all right? And if you think I owe more, then please present me with the information I've asked for above, okay? I have the right to pay no more than the correct amount, all right? Secondly, I have the right to challenge the IRS's position and be heard, all right? You're saying I owe you money? I disagree, all right? I demand to be heard according to the IRS Taxpayer Bill of Rights, and I expect a response in order for me to get that quality service that you guys offer. The right to a fair and just tax system. All right, let's be fair and just. Are you trying to pull something over on me? You're trying to make me pay for something I really don't owe? That's not fair and just, okay? You've violated my rights once again and established a clear and obvious pattern of knowingly, willfully, and intentionally violating my rights under color of law, which gives me direct recourse to such willful abuse via Title 18 of the U.S. Code, sections 241 and 242. Okay, we all know what those are. So let's be clear, guys. The IRS and its various versions, you've already acquiesced to my position, and you've agreed to my clear and unequivocal position based on the facts and the law, and there is no tax liability related to the years or the activity in question, and this has been agreed through estoppel and tacit procuration. You've procured their admission tacitly. We could also use the term tacit admission, okay? That is actually, I think I'll use that. Tacit admission, because that's in Black's Law Dictionary, whereas the other is a little bit more obscure. Okay, so if you've got any questions, let me know, guys. Here's without risk, there's no authority. Therefore, cease and desist, quit bugging me, get lost, go pound sand. And if you continue to violate my rights, I'll start taking names and numbers, and we'll see what happens from there.
Okay, Mark, I have one minor request of you. You're writing this letter, but you're signing it on the left, which is not a good form because you're not a dead entity. Okay. Sign it, please, on the right, which is also representative of, interestingly enough, what side of the document do you sign the note security on? In that stack of 900 pages, there's only one document that you sign on the right, and it's the note security. So you're a living man writing this communication in your capacity as a living man, which is also not taxable in and of itself. And by putting your autograph on the right-hand side in blue ink, then that's a very unsubtle distinction of your status. They will never send a document back to you that's signed on the right. And if they do, that means they are then personally liable for any injuries or damages. I've only had one officer write me a letter that they signed on the right-hand side. And it came from, interestingly enough, the United States Department of State and the from the Secretary of State, who signed an authentication document for me, and they signed it on the right. That's the only document I've had in 20 years.
Is that right?
Yeah.
Wow. So they do apply it when they feel they
They
need.
know. They know the protocol. And then
Wow.
the only other thing I would also ask you to do is when you're providing your mailing location, there was some discussion. I don't remember if we did it with you or not, but there was some discussion about mailing locations. This is not me that's describing this. This is the United States Postal Manual that describes locations that are zip code enabled, which is a construct of the United States, and those that are zip exempt. So if your location shows up and we're in America, the city name is followed by a two-digit code that corresponds to the two-digit code of the zip code. So it shows up as, I'm going to just use Lincoln, Nebraska. So Lincoln space 07, comma, Nebraska spelled out. Right below that, zip exempt is in uppercase letters. And then below that is without United States. That tells you that you're writing to a living man or woman on the land. And that, again, is a very distinct indication of status in and of itself.
So you can find that two-digit code in the.
Yes, you can. Well, all you have to do is find out. Like if you're in Lincoln, Nebraska, and your zip is 45102, it's the 02. So Lincoln space 02 is the last two digits of the zip code. But because of the formatting, it literally is not subject to the zip code overlay, which is also an inference of being in the United States as opposed to the United States of America.
And I think that relates back to the Buck Act, doesn't it?
I don't remember, but it may. Yeah, I have to go back and look. That sounds familiar, but this was I got gleaned that from a United States Post Office manual, not a USPS manual.
Yeah, there's a difference.
Yes, there is. And there's also a difference, just for the sake of conversation. If you're at the main station of the post office in your locale, there is no address on that building because it is on the land. So there's a difference between having a post office box at a substation and a post office box at the main office. So if somebody out there is listening to this, if you've got a P.O. box and you think that you're conducting private mailing and you're running it out of a substation, you are not. You are actually being delivered to a zip-enabled location, which is part of the United States. Move that post office box to the main office, and that particular location is literally representative of the land of the United States as opposed to a subdivision or corporate subdivision, a fiction, if you will.
That would probably only exist in the major cities, right? They have.
No, not really. Well, certainly in the major cities, but not major. I mean, if you've got a locality that has a population of really more than 50,000 people, then you have a main post office there. And again, it's really easy to verify. You drive up to the building. If you see a street number on it, you're at a substation. If you're at the main post office of Botswana, Kansas, and there's only 500 people, it's not going to have a street address on it.
Interesting.
Yeah.
You're saying that the post office or the post office would have a street address signified by the number.
If it's a substation of the main office, it will absolutely have a street address because it's not property of the United States Post Office. It's a property either owned or rented or leased, and it's on a fictional land parcel. But if it's the main office, you'll notice there's also a very distinct alignment. Even at the substation, when you walk into a post office, there's usually a door or some sort of a divider that brings you to the counter for the United States Postal Service clerks. And then the other side of the building, by the way, which is always open, is the post office boxes. So the post office boxes, the post office function is open, supposed to be open, unless, again, certain circumstances where we've got, destructive issues going on. But prior to about 5 years ago, the post office portion was literally open 7 days a week. You could walk in and collect your mail even on Sunday afternoon. You couldn't obviously get to the counter, to the clerk, but the post office portion of that building was open. And now, again, unfortunately, we've had an extraordinary, illegal immigration, homelessness, destructive acts and actions that have unfortunately caused the United States Post Office to restrict access to even the post office area, but they're doing it out of protection of the property, not because they're trying to, freak people out.
Yeah, that's fascinating. Of course, the post office was first created, with the creation of the country.
And absolutely was.
Pre-existed the United States and pre-existed the USP as Postal Service.
USPS really didn't even come to existence. The only reason I know this is my father worked for the United States Post Office, and in 1970, when I think Nixon was in office, they created the United States Postal Service, and he was quite irritable about that because and I think he fundamentally knew inside something wasn't right, but it was changing the nature of the benefits for the postal workers. And it impacted union negotiations and the whole 9 yards. Very, very interesting. And if he was still alive today, we'd be able to have this conversation in a much different light.
All right. Fascinating stuff. Love talking about this. You guys have any other comments or questions? Okay, guys. Well, I think we covered some good ground tonight. Thank you very much for your attendance and your input. And look forward to bigger and better things. Now, next week, we'll probably get into what if they did comply with all the requirements, which, of course, they never will. But we'll get into using negotiable instruments a little bit to pay things and see where that goes. Be our own private bankers. Start acting like one.
Yeah. You guys have a great evening.
Thank you, Mark.
Have a good week. Thank you. Good meeting.
All right, guys. Take care. God bless.